morning and welcome to the Florida Supreme Court. Our first case today is State of Florida versus Zachary Wester, number 2024-1769. Whenever you're ready.
Good morning, Mr. Chief Justice, and may it please the court. Jason Muhof on behalf of the state of Florida. The Florida legislature intentionally crafted the Florida RICO Act to be broad and to cover a wide array of criminal activities. As relevant here, it also made it illegal for any person employed by any enterprise to participate in such enterprise through a pattern of racketeering activity. That includes Zachary Wester's conduct here. All parties agree that he is a person who was employed by the Jackson County Sheriff's Office and that he used his position to commit a pattern of racketeering. Specifically, he pulled over unsuspecting victims, planted drugs in their cars, and then arrested and helped facilitate the prosecution of those improper drug crimes. Nothing more is needed to uphold his RICO conviction. And yet, the first DCA demanded an additional element, specifically that the state prove Wester coordinated with 2 or more people to facilitate some illegal objective. That requirement is not found in RICO's text, nor is it supported by this court's precedent or federal precedent.
Counsel, could you distinguish the requirements for a conspiracy charge from the elements as you see it for an individual person's racketeering under the RICO statute in connection with a criminal enterprise?
Certainly, Your Honor. So conspiracy is generally understood to be the agreement between 2 or more to facilitate some illegal objective. Here, you need some person who is employed by any enterprise or participate in any enterprise, and to be able to use that relationship to the enterprise to facilitate the pattern of racketeering.
So the state's position is that the substantive RICO charge does not require more than one person, but a conspiracy charge obviously would, because it would require an agreement.
Exactly, Your Honor. And of course, there's going to be plenty of times where I believe it would overlap, and subsection 4 specifically envisions the idea of a conspiracy within the pattern of racketeering, but there is universes where it can be separated.
Do you think the First District was incorrect in their reliance on our precedent to support their position? Because they leaned pretty heavily into that.
I do, Your Honor. Specifically, Gross, this Supreme Court's opinion, it's interesting what they did there. First, for context, Gross decided a circuit split on the scope of enterprise and decided it in favor of the broader definition. And in doing so, I think it's safe to say they rejected the idea that it has to be connected to organized crime. They described the circuit split really as a theory of legislative intent and whether you think it has to address the mob or something like that, as opposed to a broader connection. But there, I think they really latch on to the idea that you have to have some common purpose. And here it's clear that the sheriff's office has a common person. It is to do law enforcement. And so it's a little bit unclear how they think a broad definition of gross actually undermines the claim here, when everyone agrees that the statute clearly envisions a government entity being a qualifying enterprise.
What about Doorball?
Doorball, similar, Your Honor. I think Doorball really just stands for the basic idea that you cannot associate with yourself as the enterprise. And that makes sense. If that was true, there would never be a time where a crime couldn't qualify as an enterprise, because you always associate with yourself whenever you commit any crime. And so I think it was really just establishing that you can't go that far. But of course, what you have here is Zachary Wester and the sheriff's department being the qualifying enterprise.
Counsel,
Go ahead.
your brief or your approach to the text in some ways resembles Justice Gorsuch's approach in Bostock, just looking at the text and ignoring sort of the context when the statute was enacted. Can you start by focusing in particular on enterprise and what was going on in 1977? Can you explain, is your position more like Justice Gorsuch in Bostock or Justice Alito in dissent?
Well, it's certainly not Justice Gorsuch, Your Honor. I think what we have is more along the lines of what Justice Kavanaugh and Justice Alito had in their dissent, which is understanding the provisions as naturally read. And here what we have, and specifically through connecting the conduct in the enterprise to the pattern of racketeering activity, it is clear that what Wester did here was only made possible through his employment at the sheriff's office. He used the patrol car to pull people over. They got out of their car because he had the badge. And so we actually think that it's just naturally connecting all the terms, which I think is safe to say how Justice Alito and Kavanaugh approached it.
So you think the sheriff's office is like the mob? I mean, focusing on enterprise can have a variety of meanings, and you focused on like a positivist approach to the definition of enterprise. But there's another meaning of enterprise, just taking the context of when it was enacted, that has to do with an undertaking, some sort of, an undertaking to violate the law in some sort of organized way. And in that context, the definition could say, these are the different ways that you can engage in an enterprise to violate the law. Mm-hmm. But so you're reading it as if that is actually the definition, to the exclusion of what enterprise probably meant at the time it was enacted.
So, Your Honor, 2 points there. I certainly agree that if you were just to ask what is an enterprise in a vacuum, it might have a different understanding. But here the legislature defined what an enterprise is. And so we were applying the standard principle of textual interpretation, which is when the legislature defines a term, you use that definition here.
So but when is it fair to take into account the context in which that definition was adopted, or the entire, provision was adopted?
So I think context is inevitable to doing proper interpretation. You have to understand what the words mean, and the way you do that is by looking at the words within the clause compared to the entire statute. But I would also push back, Your Honor, on the assumption that the purpose or the context behind the statute was only to target organized crime. I think the U.S. Supreme Court makes that abundantly clear in the H.J. Inc. Case, where they specifically say, although that might have been the animating purpose behind why Congress started the process of creating a RICO charge, the words that they actually use and the words that they actually ratified go far broader, and those are the words that control here. And I think the same is true with the Florida RICO Act as well.
So I understand all of your arguments against reading the two minds thing into this, but it seems like your position is basically to kind of, I don't want to say rewrite, because I think that would be unfair, but you're basically kind of, restating what it means to participate in the enterprise through racketeering activity. And you're basically saying that if you use the enterprise to commit your racketeering activity, and I'm not sure. That seems like if I were writing from scratch, that seems like it would be a reasonable thing to do. And it seems like a much clearer way if they had just said to conduct the enterprise through a pattern, or to use the enterprise to commit. But it seems like you're you're not necessarily explaining why it was written the way it is. And I'm just I don't know that it necessarily gets to what they're saying, but could you help us understand just kind of why it would be? Because it is a very awkward, if the point is, hey, if you're part of an enterprise and then you use your authority as a member of the enterprise to then commit crimes, this particular wording is kind of an awkward way to get to that concept.
So certainly agree, Your Honor. We were trying to find some shorthand way of saying these qualifications, but there's so many dependent clauses, it's hard to, I think, put it in a more streamlined way. But what we tried to do was stick to the text and all the clauses. And so what we think the fairest reading is, and if I understand your question correctly, it's connecting the involvement with the enterprise to the actual racketeering.
And also not just the involvement, but participating in the enterprise. I think that sort of the intuitive appeal, it may not be a textual appeal necessarily, but kind of the intuitive appeal of what they're saying is that when you talk about participating in an enterprise, it kind of implies that there's some sort of joint activity distinguished here from the conducting the enterprise, which is sort of, directing it or leading it or whatever. And so it does seem like, just from a matter of language, it does seem like a strange way. If I'm just this kind of rogue person that's out there abusing my authority and whatever, that to describe, if I said to you, if I explained what this policeman was doing, I don't think any reasonable person would describe it as, oh, he's just participating in the enterprise of being a policeman by planting evidence on people. That's just a very unusual way to describe what it is that in the facts here, what was going on.
So I would say 2 points in response, Mr. Chief Justice. The first is, looking at the text, I do think that they purposely, and even if it is a little bit awkward in its wording, envisioned a very broad standard here. And so it is any person to conduct or participate directly or indirectly. And so to use that same hypothetical, if you were to ask the person on the street, I think they would say the police officer who's going rogue is at least indirectly participating, or at least indirectly conducting. And the legislature there used this kind of broad catch-all category. And then, but taking your question head on, I would also point you to the First Circuit case in Ruiz and the Seventh Circuit case in Shema. Both of those kind of address the same question, I think, which how is an officer who is abusing his authority connected to the underlying enterprise? And in both cases, I think they make clear that what's happening is he's using the enterprise and distorting it, but in a way that still qualifies within.
Is your case any stronger if there is another criminal mind in the police department or at the state attorney's office? Or is your argument sort of independent of that fact? Like in Shema and in the Ruiz case, the First Circuit case, is there any allegation in either that the police officer who was doing more or less what was happening here acting alone?
No, Your Honor. There were multiple actors in both of those cases, though when you read the analysis, I don't know that it turns greatly on the fact that there were multiple bad actors. But I do think, to answer your first question, the only reason it would be easier if there was another bad actor here is because the first DCA added that requirement. We don't think under the text that it becomes any easier or harder, but it does address what we think is an improper standard. So in that sense, certainly.
So you don't think that I understand that your argument obviously is that we can't just kind of ask what would a reasonable person think an enterprise means. We've got to look at the definition here, and it says that it can include licit as well as illicit and governmental, but it seems like, you could read that as saying that the enterprise itself has to have somehow been kind of corrupted. If you're starting with an illicit governmental enterprise, that in order to fit within this, that the enterprise would have to have been itself kind of corrupted, and then you or the actual individual defendant participates in that. I mean, the enterprise really isn't. The enterprise here is just he's a member of it, but then as far as participating in it, it's really just his own individual acts that we're talking about.
Yes, Your Honor. I would say it's more than just it just so happens that he was employed. I mean, he used the resources and the authority to.
No, I agree with that, but he still is. I mean, it's almost like he's not really participating in the enterprise at that point. It's like he's kind of off. He may be relying on his authority as a member of it, but he's no longer like participating in the enterprise. I do think it implies kind of a joint endeavor of some kind, and it could be that a previously licit thing has been kind of tainted, which I do think that that's part of the broader context of the RICO thing, is kind of taking over legitimate things and turning them into illicit operations.
So 2 points there, Mr. Chief Justice. The first, I think Chief Judge Osterhaus has a good point on this, and it's specifically that people in the sheriff's office clearly did work with Wester, as did the prosecutors, the state attorneys. Now, they didn't do it knowingly, but as the Chief Judge points out, there's no knowing or mens rea requirement within the RICO statute. So I still think kind of the concerns that you have were met here. Multiple people, whether it be the person who puts them in jail or when the prosecution comes, those are all involved in coordinating with Wester. Again, not knowing that they had done it, but
so you think so? Would it? I mean, do you think that should be, if we were to rule in your favor, should that be sort of a limiting thing? I mean, is that something that was, is that like an element of this that it just maybe so happens, but should we say that that's kind of critical to this being upheld, the conviction being upheld?
There's multiple people? Sorry, I'm not sure what the question was.
So she's saying there has to be an actual sort of joint understanding that you're going to do something criminal. You're saying that, there were other people involved, even if they didn't know about it. The other extreme would be like he just, nobody knew and whatever, but he still was using the authority of his office to do it. I mean, are you saying that middle category where where he's relying on other people in the enterprise to be able to accomplish what he's doing? I mean, is that a necessary part of him being found guilty of this?
I think you could imagine examples where it's just using the resources of the entity. Now, as applied here, yes, other people were involved. But, for example, by placing drugs in the person's car, that is a predicate offense. And yet, at that point, nobody else had been involved. So I think it would depend slightly on the facts. But to your original point, Mr. Chief Justice, about the licit or government entity having to have some kind of corruption within it, I do think that confuses, or at least doesn't give full weight to the enterprise definition. Because as I understand the first DCA and Wester's position, you have to have two illegal actors, but that is itself a separate enterprise definition. It is two people or a group of individuals who are associated in fact but not a legal entity. And so in any crime, you would just say, well, no, that was the enterprise. It was the two bad actors. And yet the legislature here gave a list of valid, whether it be a corporation, a union, or a government organization. I just don't see how under this theory you would ever have those entities be the qualifying enterprise, and yet the legislature clearly envisioned that could be the case.
Well, that's why I asked, going back to my Bostock question, it seems like you're approaching this with blinders on. You're just looking at the words themselves in a definition and ignoring the context of the entire statute and what this statute is. I mean, RICO is a very particular type of crime, and it was well known at the time in the 1970s as what was going on and what the federal government first and then the Florida government was trying to do to get at it. And you're now focusing on, oh, well, we have this definition about enterprise, and look, we can go after one individual, unrelated, he's not involved with anyone else that's trying to embark on some sort of criminal endeavor. It's just him using his employer to commit crimes. And so you seem to have expanded the reach of this crime beyond what was originally envisioned when it was enacted. And with that is, so could it be an alternative, like looking at the definition of enterprise as we're identifying all the different ways that an ongoing criminal endeavor could be, be the, not the predicate, but the base for this crime, which it seems that is the point of the crime, is that you're engaging this organized activity in some way. It may not be legally incorporated, but these are people associated to commit some criminal activity.
So 2 points, Your Honor.
And that's, was it Turcotte and Gross and Doorbal, they all seem to anticipate that as part of it.
So 2 points, Your Honor. One, this court has said time and time again that broad purposes, a statement must yield to the clear text. So we do think it's sufficient there. But I do want to take your assumption head on.
Well, that's what Gorsuch said, too.
Well, Your Honor, I think Justice Gorsuch was wildly incorrect, but that was because of the specific text of the statute. But on your point about what is the RICO Act for, I think it's 2 points. No one doubts that it included organized crime, the mob, the mafia, what have you. But the other thing, and this is in the third whereas clause in the preamble, is also the corruption and infiltration of legitimate entities. And that's exactly what we have here. Zachary Wester abused and corrupted a legitimate entity that is given great authority under the state. And so what makes his crime unique, it's not that he coordinated with other people in the way that a mob normally does. It's that he had resources that if he was just a lone wolf on his own without any institution or any entity, he couldn't commit the same level of damage, the same level of harm to these individuals. And that's why RICO has these supercharged abilities for the government. It's the ability to do more crime and to do more damage because you have an enterprise backing you. It's not just that there's multiple people in some organized scheme.
Am I correct that the only sort of purpose-driven argument comes from the Act's preamble? It's not from any statutory text. Is that correct?
Your Honor, again, we think it's a clear reading of the relevant provision. You could read in purpose from any number of sources, whether it be general.
But the first DCA used the Act's preamble.
I think it's the preamble, and I also do think it's a preconceived notion about what RICO is for. Mm-hmm. When you do most statutory interpretation, Chapter 604, you have no idea what it is, and you're informed as you read the text. I think RICO is one of the few statutes where you have a general or vague notion of what it's supposed to do, and I think that probably bled into the analysis. Happy to answer any other questions this court may have, but otherwise I will cede my time until rebuttal. Thank you.
Thank you.
Good morning, Your Honors. May it please the court, I'm Barbara Basharis, representing Zachary Wester. We're asking the court to affirm the First District Court of Appeal in their reasoning on the scope of what it means to participate in an enterprise through a pattern of racketeering activity. We actually agree with much of what you just heard in the state's argument. RICO was enacted to combat organized crime in the traditional sense and was intentionally drafted much more broadly so that it could reach more than simply, the Godfather style mob activity. Both of those things are true. RICO also applies to any person. You can be a single actor and commit a predicate act, and if you're part of a RICO enterprise, you can be held liable under RICO. But it doesn't logically follow that merely because you are employed by a government entity or a company that any predicate act you commit is going to give rise to a RICO violation.
Is that really the state's argument? I mean, it seems to me that they have a colorable argument that it isn't just the simple act of employment, it's the deployment of the instrumentalities of the office in a way that facilitates the predicate act. I mean, one way I think you could hive this off from some of the hypotheticals that you brief about how any employee can commit a RICO violation is that in this case, Mr. Wester was clearly relying on the indicia of his authority to sort of do what he was doing in terms of planting the drugs, and also was sort of using the instrumentalities of the office to advance the prosecution of his targets. It seems to me like that's different from, saying that any postal worker who steals mail from someone's post office box is using the United States Postal Service as his enterprise in a RICO charge. I mean, am I wrong? Tell me, respond to that sort of argument.
I think the problem there is that in both examples, Justice Curiel, the only reason the person had access to the instrumentalities of the offense is through their employment. And we do have, and it was charged in this case, an offense of misusing public office. But every misuse of public office is not necessarily a RICO violation. What we lack here, and what the first DCA correctly pointed out, is any acting in concert, whether with another entity or another individual, because that really is the core of what RICO gets at, over and above other criminal statutes. RICO criminalizes acting in concert to acquire interests in business and acquire control of business, or to operate a business. Those are the three main subsections of the statute, whether it's the federal or state version.
Now, what is your response to the state's argument that in acting with concert, the statute doesn't have any sort of mens rea requirement for those that the person that's being charged is acting in concert with? So in other words, like Chief Judge Osterhaus frames it as a nexus. So this isn't mere, abuse of a public position, that the person being charged is truly acting in concert with this enterprise. There's a nexus between the power and the authority that's being leveraged in this particular context, in the context of racketeering activity. So,
Your Honor, I think that reading doesn't give enough weight to the meaning of participating in the enterprise through the pattern of racketeering. There's a common sense meaning of participate, and that's what a lot of this comes back to, is what does it mean to participate? And the cases are sometimes not helpful, because in all of these different cases, people are participating in different enterprises. It's fairly unusual to have a purely licit enterprise that is alleged to have absolutely no connection to the acts other than the proximity of employment. And so the problem with that is that it takes any tool of employment, really, anytime somebody uses a tool of employment, and would allow a crime committed to rise to a RICO violation without that sense of participating with or in activities.
So can you explain that scenario? Because you started out by agreeing with the state that this could be a single actor, that the statute allows for kind of the single actor scenario. So can you describe a scenario where it would be a single actor participating in an enterprise that would fall within the statute's reach?
I think the most obvious example is, and I'm drawing a blank on the case name, but if you have an individual who is also the sole operator of an incorporated entity, who uses that entity to accomplish illegal acts, then the
So how is
that's
that any different from a factual standpoint? It's the Wester in this case is leveraging the enterprise, and this falls within the legislative definition of enterprise, even if that's not something somebody would expect, on his own, but certainly leveraging all aspects of this enterprise for the purpose of the criminal activity. So I just don't see how that's any different from the scenario you gave.
I think it's different in two ways. One is the element of control, and the cases have been fairly consistent. I realize the Florida statute and some state statutes are drafted broadly enough that some courts have said you don't have to be the director or the chief operator of an enterprise, but it doesn't follow from that everybody who is employed by an enterprise is equally responsible for that enterprise. And I apologize. Could you repeat your question? I think I've lost
the conduct. I mean, that person, if I set up an entity and then I run it and use it, then I would be convicted under the conduct thing. I wouldn't necessarily be convicted under the participate in.
That's correct.
I mean,
Chief Justice. That's correct. But that is just an example of when you could have a person. Another way that you could have sole actors is in a RICO conspiracy. You can have a lot of different people doing a lot of different predicate acts. But if they have agreed that it's in furtherance of something, then their individual acts combine to form the RICO conspiracy. So we've never disputed that RICO applies to any person. I'm just saying that logically it doesn't follow that when you have a person acting alone who does not direct or control or even corrupt the enterprise that they're associated with.
And your position would be from a top-down standpoint, I guess, because obviously this officer was directing other people's actions within the enterprise.
I don't know if it's obvious that he was directing other people's actions. I think he took actions that probably caused other people in the enterprise to do things, but that doesn't mean that he was setting the policy or creating people's job responsibilities. No, he was simply a frontline officer, patrol officer. Going back to
what do you make of the so in the definition, if we took the state's approach, the positivist approach of just looking at the words on the page, an enterprise means in any individual. So if you do the algebraic substitution and just put individual back into the statute, what do you make of the idea? So it would be a crime then for any person employed by or associated with any individual to conduct or participate directly or indirectly in such, individual through a pattern of racketeering activity. Does that even make sense? Like, it doesn't make sense.
It doesn't make sense, and I think that would make it much clearer that there would have to be two actors who were working in concert, because we know that you can't associate with yourself for purposes of RICO, and that's one of the problems with the definition of enterprise is that when you look at the cases defining it, it is so many different things. And so a lot of the language in the cases comes from situations where they're talking about a quote-unquote RICO enterprise, which might include a business, an individual, an outside contractor, all of whom were acting together. And then the defendant is alleged to have associated or been employed by one of those parts of the enterprise. Here we have one actor employed by one office, and there's nothing indicating that the sheriff's office ratified, knew of, engaged in any of these acts, or even that another person knowingly did that. As soon as the sheriff's office had reason to investigate, they did so. They suspended Mr. Wester. They severed him from those tools of employment that may have been enabling him to commit certain acts, and so the enterprise itself remained completely distinct from any of the activity. And this is where I believe the purpose of the statute is important, not the purpose of combating the mob, but the purpose of combating the infiltration and corruption of legal entities, which is absolutely one of the reasons that both the state and federal acts were enacted. I think it's proper to do, as the First District did, to read those terms in light of what the statute is trying to accomplish.
Well, it seems like you've touched on what is an ongoing debate in the originalism space. And originalists are not allowed to mention purposivism because that would be different, and that's not allowed. But at the same time, how do you approach the original meaning without considering the context, which then is going to involve looking at why, what was going on, what was being addressed by the statute? So isn't it kind of circular for the state to take the position that the first DCA has added words to it or added an element and is impermissibly looking at the purpose? At the time in 1977 when the statute was enacted, there was stuff going on. That's context for the statute. So then can't we use that to understand what enterprise actually meant? And were they just defining it, or were they giving examples of these are the different ways that someone could be engaged in some sort of criminal undertaking?
I think in the context that you're describing, it is absolutely proper to look at the purpose of the statute because that informs the meaning of the terms. And one of the reasons that I added the Dream Defenders case in supplemental authority was that's an example of this court doing that, looking at the structure of the statute for clues as to meaning of terms within, but also being informed by what the statute was accomplishing. In that
case, we were also looking at centuries of common law to understand the meaning of riot.
Well, yes, you had more to go on in some senses, Justice Curiel.
But, just to be clear, though, you're not. There's the first part of this says it's unlawful for any person employed by or associated with any enterprise. You're not denying that the sheriff's office is an enterprise for that part of the statute.
For that part, no.
Okay.
Absolutely, the sheriff's office is.
So it's not so much a matter of defining enterprise per se. It's participating.
It's
in
defining
the enterprise
participation.
Through,
exactly.
You know what I'm saying? So the whole thing about having absurd, absurd definitions of enterprise, it doesn't seem like that may be true in other cases, but it seems like that's not the problem here. The problem here is whether you can essentially be a one-person corrupter of an enterprise, of the acknowledged enterprise,
yes,
when no one else is really in on whatever it is that you're doing.
That's exactly the problem.
And isn't that what this is? Like if we know the legislature wrote this broader than what the original, the original mischief was, if you want to go with that. We know the legislature wrote it broader, and the legislature made a decision, very clear from the text the way it's structured, that it's going to punish people who leverage either illegal or legal organizations to conduct this activity in a pattern-like manner, which is what he did here. So I'm struggling to see, even if we're looking at it in context and we're looking at it with a purpose, why this is so far removed from a purpose or a conceivable purpose or the context that wouldn't be the type of punishment that the legislature is seeking to impose.
Yeah, respectfully, Your Honor, I disagree that the statute is written to punish those who leverage. The statute's written to punish people who invest in, own, operate, conduct or participate. To import the leverage requirement is just as much importing a requirement as to import a two-actor requirement. Neither of those things are explicitly in the statute. Both of those are concepts that help us get at the idea of what does it mean to participate in an enterprise. And is it enough that you simply used the tools of your employment? If so, anyone who commits a crime that was made possible in some way by being employed has committed a predicate act. And
how do you distinguish this from Shema, for example?
Shema is the most difficult case, and I acknowledge that case does not discuss the requirement of multiple actors. They may have been present. I don't remember, but the case discusses a single actor. All I can say to that is that our position is that the way that case approached the participation requirement is too broad, that simply using your position without some kind of acting in concert with another is not sufficient to create a RICO violation. It may and did create other violations in that case and this, but it doesn't rise to the level of RICO because there is no participation in the sense of acting with or with a joint purpose with some other individual or entity.
So you have, it seems like you have one of your stronger arguments is this idea of turning everything that someone does who's part of an enterprise, anything that they do, if they have enough of the predicate acts, that can become a RICO thing. But does your interpretation of the statute basically make the conspiracy part of the statute kind of redundant? I mean, is there anything that would meet your definition that wouldn't also be a conspiracy?
Yes, Your Honor. I think that conspiracy part of the statute is still necessary because particularly in an illicit enterprise or an enterprise in fact, you can have people committing different predicate acts that have nothing to do with each other. And so you can have people who don't commit the predicate acts but cause them or direct them or enable them to be done. If I knowingly give Joe a space in which to make usurious loans, or if I...
So it's for people who aren't part of the enterprise then? Anyone who's part of the enterprise, as to them, it would be redundant. But maybe if I'm helping, if someone,
I'd say somebody who's not who hasn't committed specific predicate acts, but who is part of the enterprise, that would reach part of the enterprise in that larger sense, in the definition of an association of people working for some common purpose. So you wouldn't be able to avoid liability under RICO by saying, I never broke Joe's kneecaps. I never made that loan. I never bribed that official. If you knowingly participated in some way in making that come about, that's what the conspiracy is.
Why do you so freely concede that the sheriff's office is an enterprise?
Yes.
No, why?
Oh, why?
It seems to blow your entire case. Just to be honest with you.
We concede that it is an enterprise for purposes of that subsection 3, a person employed by or associated with any enterprise.
Right.
But what the sheriff's office is not, in the sense that many of the cases discuss, is a RICO enterprise, because it did not.
So what you're saying is that the sheriff's office could be an enterprise if used in some sort of criminal fashion. Say you would have a more difficult case if your client was working with the sheriff or the undersheriff or someone else in the organization.
Or if my client was the sheriff. That would be, I think, like the Ruiz decision. I believe that was an example of a sheriff, the actual sheriff misusing the office, because at that point the sheriff has the power to direct others to engage in the acts in furtherance of the
well, that
enterprise.
Seems to confuse an abuse of power violation or a 1983 violation at the federal level. How do you otherwise make the distinction between 1983 and RICO if anyone that uses a government entity and abuses their power, I guess, is both a RICO violation and a 1983 violation? That doesn't make sense either.
No, Your Honor, it doesn't. And the reason that it would that would be true, I think, of the sheriff or the operator of an enterprise or somebody with managerial or ownership control, is that is what RICO, one of the things RICO was designed to do, is to go after the corruption and the misuse or the acquisition of illicit interests in enterprises. But here, the tension that you're pointing out is this is the case where that arises, where you have somebody who simply is employed by an enterprise. There are other ways of penalizing the misuse of someone's position. And when there was no acting in concert, either with the enterprise or with other people within the enterprise, there simply isn't a RICO violation because nobody participated in the enterprise through the racketeering activity.
You can have 30 seconds to finish up.
I apologize, Your Honor. I just want to close by saying that the plain common sense meaning of participate does not reach as far as the state's position here. I think people reading a statute, understanding what participate means, would automatically understand that it assumes some level of concerted action, which means working together with others in a common purpose, and that simply was not present here. And so we have law violations, but not a RICO violation. If you have no further questions, thank you.
Thank you very much.
Well, Your Honor, I was happy to answer any questions that you may have, but otherwise I'd like to make a few quick points. First, about the direct or conduct test that opposing counsel was talking about, that comes from the U.S. Supreme Court in Reeves. We don't think it's applicable here. Very clearly, the U.S. Supreme Court was wrestling with the oddity that is having conduct twice in the same statute. But even if you did think it was a relevant standard, Wester here would meet that test for the same reasons outlined in Shema. But
sorry to interrupt you. Could you just address this point that if there are a sufficient number of predicate acts, that basically anybody who is employed by something that meets the definition of an enterprise and then abuses their authority, whether it's someone in a private business or a government person, that basically that also would be a RICO violation?
So if you just so happen to be employed and you...
I'm not saying I'm employed by the postal office and then I'm out like robbing 7-Elevens at night, but it's I wouldn't be able to do it without my job.
Then I do think you're very close, Your Honor. RICO by its nature is very fact intensive, so it does depend on the set of facts, but the state is comfortable with saying that in many of those instances it very well likely might be a RICO charge.
And should that, I guess, I know that the sort of stock answer to that is, well, go to the legislature and change the statute. But, if we're trying to kind of give a reasonable interpretation to the statutes, does that seem reasonable to you?
I do, Your Honor, and this gets to Justice Tannenbaum's point about kind of the reason behind the act, and I do think it's twofold. One, to give law enforcement greater tools to address organized crime, but two, in an era then as now of dwindling support and trust in institutions, to say we have an obligation to make sure that these institutions aren't corrupted, and Wester is about as bad an example as you can have of that happening. So
okay, thanks. Does anybody have any questions? Okay, you can have 30 seconds to finish up.
No. Your Honor, we're happy to stand on the plain text of the statute, and with that, we respectfully request that this court quash with instructions to reinstate the conviction. Thank you.
Thank you. We appreciate it.